All right, everybody, we will go ahead and get started with our conservatorship webinar. Thank you all for joining. This is our first quarterly webinar that we are doing through the Volunteer Lawyers Initiative here at West Tennessee Legal Services. We have with us today Pam Wright, who's going to speak about conservatorships. Just a few quick housekeeping notes. Make sure that you submit your CLE form to me by April the 9th. That link is in the registration email, and then I will also be posting it in the chat box. And then we will also, I'll send that out again with the recording of this. If you have any questions for Pam during this session, please put them in the chat box, and we will make sure that we get to as many of those as possible. But we'll go ahead, and Pam, I will turn it over to you. And you should have the ability to unmute yourself, and you should be able to share your screen as well.
Okay. Thanks, Andy.
Absolutely. Thank you.
Yeah, let's see if I can get. All right. So today we're going to talk about conservator basics. I'm Pam Wright. I'm a local attorney in Jackson, Tennessee. And I'm going to disappoint everybody because I am not going to talk about any movies or Britney or the Free Britney movement or any of that. So if y'all came for that, all I can tell you is that Britney did file a petition today to have her temporary conservator named as the permanent conservator rather than her father. That's the latest news I've got. Okay. So let's get started. Andy will have provided you with an outline that lists a lot of resources that are available online. A lot of the basic information, the things that you need to know about conservatorship as a concept, the best practices, some of the policy considerations are available online, and there's some great resources there. The resource list starts on page 2 of that handout. There's national resources and state resources. On page 3, I listed national resources, and I want to just note 2 of them that are particularly valuable. One is the American Bar Association's Commission on Law and Aging website. There's a lot of good materials there. Some are really dig deep into some concepts about capacity and the roles of the various lawyers in a proceeding, and some are about policy initiatives, but I think all of them might be of interest. And also the federal government has an administration on community living, and their website is really valuable. Some of the materials, some of the links that I listed are from the National Center on Law and Elder Rights, and they have good basic information about several legal topics, including conservatorship. And there's also this Technical Assistance Resource Center for Adult Protective Services. And there's a lot of good information there about dementia, self-neglect, abuse, and exploitation, topics that conservators often have to deal with. But more important are the state resources. Whoops, I'm getting ahead of myself. I want to note especially the Office of Conservatorship Management. This is an office of the Metropolitan Government for Nashville and Davidson County. They have a general information posted. They have a basics training video in sections, and it's designed for family members that get appointed to be conservators or want to know more about being a conservator, or general people in the community, and they can go through the training and use the resources, and they have some forms. And they're actually advocating, there was a recent column in the Tennessean by their director, Amy Willoughby Bryant, advocating to have this kind of training used statewide and some statewide oversight for conservatorship. So I believe we're going to see more about that, but it's a really valuable page. I recommend visiting that. Also, there's a Conservatorship Association of Tennessee. It's not terribly expensive to join it if you're interested. They have a lunch and learn posted on their website, and there's the information. It's coming up April 22nd. The speaker is a former judge who actually wrote the Groves decision that's listed in your materials, and that's kind of the overview and the main case law that you look at to learn about conservatorship in Tennessee. Also, they have a position paper that about conservatorship and supportive decision making. And that's if you're not familiar with that, supportive decision making is a concept that's used with younger adults especially, but with any adult that might have an impairment or in judgment or cognition and needs assistance in handling their own affairs, but they also want independence. So they might draw up an agreement where some things are done by their support person, a person who agrees to help them, and some things are done by themselves, and that's reviewed periodically. You need to know more about supportive decision making. It is considered a less restrictive alternative to conservatorship, but also it's required in the Medicaid home and community-based waiver programs. So if you're helping a family or an individual who is involved in any of the TennCare programs that provide services in the community, whether it's a group home,
Hey, Pam, we lost your video and your screen share. Can you hear me?
can you hear me?
Yes, we can hear you now.
Okay. You want me to try it again, or do you want to do the screen?
I can do the screen, whatever works for you. Let me get it pulled up.
Let's do that because
Okay.
I think that may be what we're running into.
All right. Give me just a second. And then. And then what slide were you on?
Next one, that one.
This one? All right.
Yep. And anyway, so you're going to run into this particular supportive decision making and how to interact or interface that with your conservatorship. So I definitely recommend that you try to learn more about it, and you might want to read the position paper that's at the Conservatorship Association website. There's a little bit more on a couple other links there if you want to learn about supportive decision making and how it's done in the Medicaid program. It's not difficult to coordinate between conservatorship and supportive decision making, and it may never come up in your practice, but I just wanted you to have the references in case it does. So moving on to the next slide. When I think about conservatorships, I think of them like, they come in all different sizes and shapes and flavors, just like any other lawsuit. Some of them are focused on the protection aspect. Somebody is being taken advantage of, and you want to get a conservator in there to protect them. Some of them arise out of conflict situations, family dysfunctions. Some of them you're just trying to solve a problem. You've got somebody that needs some things that you can't help with without a conservatorship, without somebody in place to make decisions. And some of them are strictly transactional. You're just trying to get into a bank account or a retirement account, and somebody can't manage the paperwork, and the company won't deal with anybody. So most of the conservatorships are a combination of those things, but I will say that some are complex and some are simple, but they tend to be complex when there's a lot of money involved. Because when there's not a lot of money involved, things get simple really fast. Because when people realize that it costs money to contest every little provision, they start being much more amenable to working something out. I'm not going to dwell on complex cases. This is a basics training. So I'm just going to go through the most simple case I can think of. Next slide, please. And this is a unicorn case because very seldom will you see a case that is this boring. There's no drama in this case. Gloria has suffered a stroke and she's got serious effects from that stroke that she's going to need long-term care and some treatment. She lives and owns a home in Jackson, Tennessee. She has 2 adult children. Neither of them have a disability. And they're both really anxious to take care of their mother and make sure that she gets everything that she needs. Gloria is in rehab right now. Jean, the complication is that the children live out of the county, out of state, in fact. But they both agree they think a conservatorship might be the right thing because there's no power of attorney in place or that they're aware of. So Jean comes to you, next slide, and she's going to be your client. Now, Jean thinks a conservatorship is needed, and after you talk with her, you think she's on the right track. You've got some more things you might need to investigate, but it sounds like that she's a reasonable person and she's trying to do the right thing for her mother. And so you want to work with her on a conservatorship, and you understand, and you want to make sure that Jean understands that if you represent her, she is your client. Both of the children might have similar goals and they may both want to be involved in the representation. If they are, if it's a joint representation, then you want to make sure that you have them sign a statement where they acknowledge they understand that you're representing them jointly. And if down the road there's a conflict between the two, you'll have to withdraw and they'll have to get their own attorneys. I've done a number of family representations and I've been very lucky that they all stayed on track and worked out. But you always want to prepare for the worst and, just in case. So make sure you've got something in your file that identifies, that confirms that you have talked to them about that potential complication. And also in your letters and your retainer agreement, you want to make sure Jean understands she's the client. A lot of people think that the person who needs the help, like Gloria, is the client. They think that you're taking an action to help Gloria. And certainly in this situation, you are. Everyone is acting, as far as you can tell, to meet Gloria's needs, but she's not the client because the action that you're taking removes her rights and is considered an adversarial action. So after talking with Jean, she's willing to come down for a court hearing. She understands that would be required to be in Jackson, and she's got to come and check on the house and check on her mother. So she's thinking that she should be the petitioner, and you need to figure out if she's a good candidate to be the petitioner. So in your resource package, I listed in that handout, I listed, and this is not exhaustive, but I listed lots of the Tennessee statutes that came to mind as I was mulling this over and talking to Andy about what people might need to know. So I try to come up with a list of things that commonly come up in things for you to think about when you're putting together a case and putting together a petition. So the first step is to figure out who is the petitioner. Now, Jean certainly has knowledge of the circumstances, and the statute requires that. Jean is not, if Jean has a criminal history, she's not precluded from being the petitioner, but she has to include a statement of criminal history. I don't know why, but that's what the statute says. And you always want to warn people about that and talk to them about that, because lots of people have a pretty, I mean, not lots of people, but a number of people have criminal histories, and some of them may be pretty innocuous, and they might be shocked that somebody would want to know that. And also, they may not want to put it in a pleading. So that's something you might want to ask them about. And then you have to think about your strategy, because you want to put together a package that's as streamlined as possible and easy for the court to make the findings you want and confirm the need for the conservator and grant your petition. So one of the things you might do is have both Jean and her brother as petitioners. And again, they both have to meet basic criteria. And they have to have a common goal, which you think they do. But again, you want to watch for the potential conflict situation. So you want to think down the road what might arise that might create a conflict. Can they both operate efficiently as joint conservators? I mean, not conservators, as petitioners. You'll have to get, original signatures on certain papers from both of them. The other thing you might want to think about, even though John is not a defendant in the case, he is an interested party who has to be involved. You have to send him notice of everything. So one of the things you can do is file is to send him a copy of the petition around the time you're filing and have him acknowledge that he's received it, and he can waive service. And he can also provide a statement that he consents to some of the things that you might be asking for in the petition. For example, he can consent to having his sister. He has no objection to having his sister named as conservator. So that's one of those things you want to think about when you first get started, because the petitioner is your first step. Okay, next slide. I'm sorry, this is so strange not looking at people. No, back to the next one. There you go. Thanks, Andy. Okay, the other thing that you want to think about when you're putting together who's going to be the petitioner, oh, wait a minute, is how you're going to serve all of this and the situation with the prospective respondent. Now, Gloria is getting care in a facility. She's getting rehab for her stroke. So getting service on her is not going to be difficult. She's in one place. She's not going anywhere. And in fact, even during COVID, if you couldn't serve her personally, you can actually serve her, the institution where she's living. And that's pretty easy to arrange. They understand the concept generally when you call. When COVID's over with, in most counties, the judges like for the guardian ad litem to serve the petition, and Tennessee statute specifically allows that. But there are some judges that prefer for you to use law enforcement and do the full service through that. So you want to think about that when you're doing the petition and how you're going to coordinate that with an out-of-town petitioner. The other thing is, I hate to set hearings without, checking with the other attorneys involved in the case. But sometimes for a conservatorship, it might be a good idea to get a tentative court date so you can go on and prepare a notice of hearing that will go with the petition. And if you do it far enough out, especially if you're coordinating with an out-of-town petitioner, if it's local, it's not quite so difficult. because you need to have the notice of service, the notice of hearing served also. And it includes a specific statement of rights. So it's nice to have all of that packaged together for the guardian ad litem so they can serve it at one time. And then if you have to amend the notice of hearing and make other arrangements, you can, but you will have accomplished your service of notice. And those rights can be explained. While I'm on the subject of different judges wanting different things, different clerks and different judges, there are not major things, but small things that are different in every jurisdiction. So it's a good idea to check in with a clerk if you've never filed in their court. I'm sure plenty of clerks can tell you that I'm pretty goofy because sometimes I don't ask them about things and make assumptions. And then when I get down there to file, they think I'm crazy because I don't have a particular document or something. Some of the fees are not the same everywhere. They're similar, but not exactly the same. Like I say, some of them want service handled a different way than the neighboring county. Most of the judges want a guardian ad litem appointed. So when you go to file a petition, you should have an order prepared with a blank to appoint a guardian ad litem. If the judge don't want one, the judge can trash that or that order. Judges like to be able to fill in the name. Sometimes they really welcome a recommendation and sometimes they're put off by that. They don't really want it. But the statute says you can make a recommendation if there's a particular person that might have knowledge or experience that's relevant to your case. You would want to explain that if you do. Some of the, especially during COVID, scheduling hearings has been a real challenge. But even in regular times without a pandemic, different judges schedule differently and they have these crazy travel commitments when they circuit ride. So you have to be aware and work with the judge's office on scheduling usually. Some of the clerks will want to prepare the oath for the conservator or prepare the letters of conservatorship. Obviously, you don't do those with the petition, but you definitely want to ask about that because some of them want you to prepare those documents after the hearing if you're successful. So, next slide, Andy. So the next big question on your petition is oh, sorry for that typo. Who's the proposed conservator? Can Jean be the proposed conservator? Do you want co-conservators? Does the family insist on that? Do you want divided conservators, person and property? A lot of that depends on the family situation and what you're seeking and what the respondent needs. On co-conservators, if everybody's together and they're working together and they're in the same spot, that may not be a problem. You're going to find, like if there's retirement assets, retirement funds or pensions or dealing with financial houses, they're going to want signatures from both conservators. Unless you divide it by person and property, and clearly in the proceeding and in your order. So that's one of the things that you have to think about. And also, can they work together? That's the other thing that you have to think about. So who can be a proposed conservator? There's actually a statute that gives priorities for consideration. And on the next slide, I've got the site for that. And there's some criteria. The proposed conservator can't have had a criminal history that includes the imposition of a sentence of imprisonment in the penitentiary. Now, there's been discussion about that, like what if a person had diversion, but the sentence still included the possibility of imprisonment? I don't know the answer to that, but you need to be aware that that's a requirement, and that can keep you from naming certain people as a proposed conservator. The clerks generally are checking on that now, and sometimes especially the clerks that prepare their own oath, will include that language in the oath so that when the person is sworn in as a conservator, they're also swearing that they have not had a sentence of this type in their personal history. Also, if there's a situation where somebody is handling a decedent's estate and one of the beneficiaries, say, needs a conservator, there's some exclusion of somebody serving both fiduciary roles because there's an inherent conflict, but there's a statute that covers that. And in the priorities for consideration, family is generally given a priority. There's a whole long list. And if you don't use anyone on the list, then you have to explain to the court, either in your pleadings or in testimony, why none of those people listed in the statute are available or appropriate. You don't have to worry anymore about non-resident fiduciaries, meaning fiduciaries that are not residents of the state of Tennessee. You just state in the petition that your proposed conservator intends upon appointment to register with the Secretary of State's office and be registered as a non-resident fiduciary. And this is simply a one-page form with a $10 filing fee. And then that person is listed on the Secretary of State's website in case somebody needs to bring suit and serve the conservator or serve the estate of the person under conservatorship. They want that registration there so that there's a way to do that. And you also want the court to know that your proposed conservator is willing to serve. You don't want to file a petition and offer somebody to serve. And then that person say, oh no, I never intended to do something like this. I'm out. Because then you've got to go back to the court and figure out what to do. So definitely get that statement of willingness signed and try to put that in your petition package so that you can show the court that the person you're proposing is willing. Now, that doesn't bind the court in any way to appoint that person, but it definitely clears out something that can create a great deal of confusion. Also, if you're dealing with an estate that has some sizable property or real estate where you think a bond requirement is going to be imposed, and the statute can give you the outlines for that, you need to consider the person's ability to be bonded. They might be eligible to be a conservator, but they may have the kind of financial or personal history that an insurance company would look at and say, we're not going to write a bond for this person. So be aware of that, and you want to, do some backgrounding on your proposed conservator. Okay. Next slide. Another important piece of your petition is the requirement to have a sworn statement of medical examination. So the person has to be examined, and it can be a psychological or physical medical exam, but there has to be an examination, and then a sworn statement is provided about the examiner's opinion as to disability and the need for appointment of a conservator. Now, occasionally I have not gotten the examination because of some circumstance before I filed the petition. And let me just say, don't make that rookie mistake. I've done it twice in recent years, and one worked out great, but the other one I really thought we were headed for a problem. But if you can find any way to get that report done before you file, that's what you want to do. If you know there's no way to get that done, then you know that you can file, and you'll set a hearing to ask the judge to get the judge to order that an examination be done. And that's a lot of difficulty, and it also creates more turmoil in the conservatorship. So do the best that you can to get one of these reports done. A lot of times, if you go on and do a form for the report that you send to the physician, so he doesn't have to dictate a letter, he or she doesn't have to dictate a letter, you probably get an easier and more prompt response and maybe something more geared to what you're looking for, as opposed to just a letter that says she's incapacitated. I mean, you just need something a little different. I use a modification. I had some different modifications of the form that's in the Tim Takis Elder Law book, Tennessee Elder Law by Tim Takis, that's offered through, I think, Lexis. But there are also, there's also sample report forms online and in other references. But it can really help. And you don't have to have them use a notary. Be sure to include the language for declarations made under penalty of perjury, because it just makes it easier. They can sign off on it and not have to go hunt down a notary. Some of the physicians are so used to having things notarized, they'll put a notary seal, get it written out on there anyway, but that's a way you can make it easier and more simple for them. So I also, if I can get some medical history, I don't like putting too much of that into the petition just because of the privacy issues. But in some circumstances, you really need a detailed medical history, something more for the judge to see and also for the guardian ad litem. And if you can get that, you can make it available to the guardian ad litem. You don't necessarily have to file it. That can be part of the guardian ad litem's investigation. Or if you want to file it, I would recommend that you move to put it under seal, have it filed in a HIPAA compliant way, because you probably got it through somebody's HIPAA release. So you want to make sure that you follow the steps on that. But there are some situations where it's really helpful for the judge, and the judges will review that medical information. They really appreciate it. Also, one of the things that most of your clients and even the doctors don't realize, next slide please, is that the standard here is not incapacity. And this is just a widely held belief in the community and among the various players, is that you either have capacity or you don't have capacity, like a light switch, on, off. But in fact, it's more like a dimmer switch. In fact, it's really more complex than a dimmer switch, but that was the best analogy I could think of at the time. In some areas, you may be highly competent, but you may be less competent in managing another area of your life. So it's very complex. And that's the type of concept that's discussed in the Groves decision that I mentioned, and that the references in your materials. So that's why Tennessee's law and all of the states have moved to some degree in this direction. It's not like it was when I was very young, where you were either under conservatorship all the way, you lost every right, or you weren't. Now, every conservatorship almost is tailored in some way to the individual. If it's very complete, we usually just call it a conservatorship. But if you start fine tuning and leaving some rights with the individual, then we call it a limited conservatorship. But you'll find in the statute that the findings that the judge has to make do not include a finding of incapacity. Next slide, please. The court findings that are required are that the court finds by clear and convincing evidence that the person is under a disability and the assistance of the court is needed. Now, the disability may not be major. The person may need the assistance of the court because of one aspect of their life that is putting them at risk. But the court also has to find that the proposed conservatorship or limited conservatorship is the least restrictive alternative. If there's a way to help the respondent that doesn't involve removing rights, then the court is not going to grant the conservatorship. And so less restrictive alternatives. I mean, it may be that person retains the capacity to do a power of attorney. It may be that the person's management of property involves nothing but the management of government check, which I'll talk about in a minute, and doesn't require a finding by a state court, but rather by the agency that issues the check. It But these findings also give you a frame where you can see how you would tailor your petition and ultimately the order as the evidence is collected and the recommendations of the guardian ad litem obtained, or any adversary hearing is held. It gives you an idea of what you're looking for. You're not looking to completely extinguish all rights. That's just not the way it's done anymore. You're just trying to find, does the person have a disabling condition that requires the assistance of the court? So another thing that you'll have to figure out to frame this are the finances. What are the property management needs an individual has? So on the next slide, I list a few of the considerations for that. You're going to, the family, I mean, this is quite common. And for those of you that do these conservators, you're used to this. The family, for example, Jean may have to come into town to visit Gloria, go over to the house, and then go through every desk drawer, every bureau drawer, a million boxes and Rubbermaid containers of papers to try to find the basic financial information. Sometimes it's not that difficult. You yourself, before you ever file a petition, need to do some due diligence search. And it can be, there's a number of online databases, public databases that can give you an idea of what information is available in the public realm. You can just do a basic Google search and find a great deal. If you can find a deceased family member, you can verify who the other family members are. And if you, that's very important, because when you file the petition, you're supposed to give notice to the closest set of relations. And literally, I've been involved in cases in West Tennessee where the petitioner did not reveal the names of all the family members in the petition. And sure enough, after the conservatorship was granted, relatives came out of the woodwork who had not been served or given notice. And it creates a very difficult situation. It doesn't make the court very happy either. Run the lost unclaimed property or lost insurance policy, some of those public databases, you want to run those searches if you can. Or if you need to, the court can actually issue an order authorizing the petitioner to make an investigation. More commonly, what we see in our area, in the counties where I've worked, is that the guardian ad litem is granted authority under the guardian ad litem statute to investigate. And some guardian ad litems are great at doing that. They know who to call at the various banks, and then some of them don't. And also some of the guardian ad litems know they'll get paid for that work, and some of them are doing pro bono work or not going to get a fee. It's an informal pro bono. So they're less thorough because they believe there's less assets, given the situation. So you have to kind of figure out what works for you in your situation. But if you know there's going to be a guardian ad litem or even an attorney ad litem, also, as petitioner and petitioning attorney, you can really help yourself if you can provide basic information for those folks. Don't just leave them hanging out there. Make sure you give them the family contact information you have, what you do know about the finances or what you might know about family history and medical history. You're going to help yourself and you help them do a better job, but that you're trying to get your petition granted. So you want to make sure you've got a working relationship there. So that's something you do as you prepare and put together the information for the petition. Often people will put a inventory, even kind of a cursory one in the petition to meet the inventory requirement. That's actually a requirement that is not supposed to be waived. Sometimes it's waived. There's some things that are in the statutes that We don't all hit all the marks when we file our pleadings, and the judges don't always hit all the marks when they make the rulings, but they have a lot of discretion too. So sometimes it's just not they know and they're using their discretion. So sometimes they'll waive all of this if they know, for example, that somebody's only property is SSI. They know a government agency has been looking at that, and they know what they're getting, and they don't fool with the rest of the paperwork or put a burden on the respondent. It just depends, but the statute does require an inventory, and the statute also in the courts understand that a conservator may come in and not be able to find all the property right away. So you can always amend the inventory. Don't worry about that if you can't find it. But if you don't have to put it in the petition, it is helpful for the guardian ad litem to have some direction on that though. So on the next slide, I want to talk about government benefits and remind you that a state court has no jurisdiction over benefits or income that is granted by a federal agency. So a court can tell a conservator, I want you to apply to be a rep payee, but the federal agency controls that. So I've got a little more on that. Next slide. Common representative roles that you might see for government benefits. They're created by statute or regulation, so you can find it easily online. Generally, they're called representative payees. The one that we're the most familiar with is the Social Security representative payee. Almost everybody has seen that situation. And the representative payee is not necessarily the conservator. That's certainly, if the person is named conservator, Social Security considers that in their decision and quite often, works that out. But it's not always the same person, so keep that in mind. VA fiduciaries, that's highly regulated by the Veterans Administration. State of Tennessee has separate statutes. When a veteran is getting a conservator, this slideshow doesn't cover that statute. That's something you'll want to get into if you have that situation. And I'll have to say that Tennessee, generally, most of us have not been hugely compliant with that as much as we are now, because the VA has stepped up their oversight. If you have somebody who is a veteran, maybe the conservator family member becomes conservator and down the road they apply for veterans benefits, you do have to send all that in to the VA. Fortunately, we have a State Department of Veteran Affairs, which is fantastic. And many of the counties, if not all the counties, have a veteran service officer in place. Those people know the system. That's what their job is. So if you run into that situation, I always recommend, unless you're a credentialed attorney who handles VA applications, you need to talk to your veteran service officer, your VSO in the county that you're in, that you're filing in, and or the Department of Veterans Affairs, the state office. There's an office of that department in the Jackson State Building on Martin Luther King. That's the regional office. So next slide. Here's a railroad retirement is like Social Security, but they have their own statute. Same thing with black lung benefits and some of the other benefits that that you don't run into as much, but are federal benefits. Also keep in mind, and it's not unusual to have a retired federal employee that is governed by the Office of Personnel Management, and they have their own guidelines too, but they're really good about putting it online. And there's an organization for retired federal employees called NARF, National Association of Retired Federal Employees. And they have really good question and answer information. So sometimes if there's a situation there that the conservator needs to work out, they're really helpful in retirees' needs. So, okay, next Next slide. Now, these are not income streams from a federal agency, but these are federal programs that offer benefits. Food stamps, TennCare is Tennessee's version of the Medicaid program, and Medicare, which is the insurance program that's federal. They have online forms that you can download for authorized representatives. You don't run into that very often, but I think you will more and more. You will run into it every time with TennCare. Even if you're a conservator or if you have power of attorney, TennCare will not talk to you unless you have a signed form that says you're an authorized representative, signed and dated on their form. And then it has to be submitted to TennCare. Now, if you're a conservator for someone who no longer has the capacity to sign that form, you can sign the form as the conservator. So Jean might sign the form as Jean, conservator for Gloria. That would be Gloria's signature, or Gloria by Jean, her conservator. And then she has to sign it as Jean, accepting the appointment as authorized representative. So that's very confusing for family members when you tell them, well, you've got to sign this twice, and no, they won't accept your power of attorney, but you have to provide the power of attorney to back up your signature where you signed as attorney in fact for Gloria or conservator for Gloria. You have to provide the order. So because you will run into TennCare issues quite often, I wanted to make sure that you knew about that. That form is available, can be downloaded easily from the TennCare website. But it will stop you from getting any information from them. Also, with your Medicare enrollees, a lot of times conservators will step into the situation, be named conservator, the person they're helping has Medicare, but they don't know that there's different kinds of Medicare, and they don't know exactly what they have. So it's kind of like looking for financial assets. You have to try to dig out their cards or call the treating physician's office and see what they have on file, because the individual might have signed up for a Medicare Advantage plan, and that would have different coverage, a different set of benefits. It operates out of a different company. And so you have to get that information. And then the company, if it's a Medicare Advantage plan, may have their own authorized representative form. So that is another sticky wicket that you need to deal with. Andy, the next slide is on emergency actions. Is this a good time to check on questions?
Yeah, currently we have not had any questions come in. If we do, I will let you know. I know that beforehand we talked and there were some emergency action questions that have been brought to me, and I passed that along to you. So I think we're good to go right now.
Okay, so I'll talk about these generically because I haven't really outlined them much on the PowerPoint, but these are the emergency actions that you're most likely to see in state court. We don't see that many actions brought under the Adult Protective Custody statute. That would be a petition filed by Adult Protective Services, but they do occasionally file them. They may be involved in a case, and they may try to encourage somebody else or push somebody else to file. They consider themselves the entity of last resort, and also their jurisdiction is extremely limited. They have a very limited jurisdiction of when they can actually take part in a person's protection and go to court. So that statute is listed, but you won't run into it too often. One that is quite often used is the limited healthcare fiduciary. These are generally filed by healthcare facilities. They have somebody in the facility, and it may be, there are less restrictive ways to get a medical decision maker because there is provision in the Tennessee Medical Decisions Act to have surrogates named when there's not a healthcare agent in place. Now, a healthcare agent would be named by the patient. A surrogate is named by a treating medical professional for the patient's benefit. But sometimes you've got a complicated case, a complex case, big decisions, and the facility wants the court to appoint a fiduciary rather than using the surrogate route. And that's a time-limited appointment. Sometimes there'll be a guardian ad litem. They'll request a guardian ad litem, and that it's not a huge, doesn't come up a lot, but those are getting to be more common. I'm going to skip emergency conservatorship just for a minute. Involuntary commitment is a mental health. Most of us are familiar with Western State being the regional hospital under the Department of Mental Health and Substance Abuse system. And they have their own little courtroom in the on the hospital grounds where they handle commitments at that facility. Other courts have mental health jurisdiction and can do these involuntary commitments. In your resource material, I have the link to the website for the department, the State Department that governs this, and they have forms on there. So anything you need about that is on there. And I've actually had good luck calling their Office of General Counsel for guidance on some situations. So I would just say that that's a really helpful thing. They have, the big thing you need to know is that there's a difference in the statutes from medical decision-making and decision-making under Title 33. Title 33 is related to behavioral health and substance abuse issues. So it has its own standards and its own mechanisms for imposing things or dealing with consumer rights. And that's pretty helpful to review if you're running into that situation. Sometimes a conservatorship might be a help for the family, but they may need something entirely different. So you need to be aware of that if you're dealing with behavioral health issues. And also the state law provides for emergency transport if someone's in an emergency mental health state. It needs to be transported to the emergency room or to an inpatient health facility setting. For older individuals, they might go to the emergency room and then be transported to a geropsychiatric unit. They're not in every county. One in Madison County is Perimeter. It used to be called Oak Hills. It's in the old regional hospital location. There's one called Unity in Martin. There's one in Perry County. I hope it's still there. I know Perry County Hospital is closed, but I don't know if that's permanent. There's some in Memphis. So you run into these, particularly with older individuals. They have to be 55 or older. And sometimes an assisted living might need to make that call and have them transported. So the Sheriff's Department can handle transport. In Madison County, Chancellor Butler keeps orders, pre-formatted orders that a family can fill out without the benefit of counsel, and then he'll review them with the individuals. Question from Lloyd is, does Chancellor Butler have any particular likes or dislikes on conservatorships or on transportation? On transportation, he is my experience with Chancellor Butler, is that he is very family friendly. So if you go up there on the transportation and it's just family, he is very great. Oh crap, my battery's running low. About talking to the family and signing those orders without them having to go through hoops if he recognizes the situation being emergent. Conservatorships, I find that Chancellor Butler is also great to work with on those, but he is going to hold you to the statutory requirements. So if you don't have your evidence in order, he's going to point it out to you. He likes the guardian ad litem to do a full investigation. He's happy with that. And he also will do in chambers conferences when he sees a need for something, but he's not getting what he needs from the attorneys. So he'll be happy to kind of, direct you and give you an idea of what he's looking for because he wants to solve the problem. I find him great to work with. So I'm glad you asked that. Finally, one thing that people forget about, but we're so aware of public health right now, is that the public health actually has the authority to take people into custody and remove rights during an emergency, or because someone has a highly contagious disease and they're putting others at risk and won't comply with any directives. So that's something else that you might find of interest, but I don't think you're going to run into. Emergency conservatorship. Keep in mind that this is a completely separate thing from a regular conservatorship, but based on my conversations with other attorneys and other attorneys and other judges from time to time, you can file an emergency conservatorship and proceed under that statute. But if you know that you ultimately want a regular conservatorship, the judges are very welcoming of an amendment, a motion to amend the original filing to a regular conservator. So you can start an action where there's an emergency. You do not have to have the sworn medical statement. The petitioner has to be someone who's interested in the respondent's welfare. It does not have to be a family member. The petition has to state that if the petitioner were to comply with the regular procedural requirements of conservatorship, it would likely result in substantial harm to the respondent's health, safety, or welfare. So that's a pretty generic kind of statement and can apply to a lot of different situations, but it's got to be emergency. And you've got to show that no one else appears to have authority to act on the person's behalf. And the notice requirements are very stringent, and there has to be a hearing to confirm appropriateness when you use an ex parte order. So I've outlined that a little bit in your outline. And also, I don't know if Andy still has these, but I still have them. At one time, Chance.
I'm assuming that Pam's computer died, so let's give her a few minutes to get back on because she's no longer on here. While we're waiting for Pam to come back, I will make a few announcements. The reason we did this first webinar on conservatorships is because West Tennessee Legal Services has expanded our contract attorney program, and we are now allowing for, or we've talked with some courts and are trying to get some guardian ad litems appointed through our office for people who qualify for our income and asset requirements for our grant. We are doing this through our contract attorney program, which allows us to pay our volunteer attorneys or our contract attorneys $75 an hour to do the guardian ad litem work. As Pam mentioned earlier, in quite a few situations, especially with lower income clients, the guardian ad litems end up not getting paid. So we have made that decision in most of our counties, with the exception being Madison County, just because there are more attorneys that can take pro bono cases in Madison County. But if you're interested in joining that program to do guardian ad litem work for a reduced fee of $75 an hour that can be paid every month and guaranteed, then we will then please let me know. I think this is Pam. Let me allow her to speak. Hey Pam, is that you that has called in?
That's me.
Okay, perfect. Well, once you finish
I'm so
up.
sorry. We knew something was going to happen. Yeah, I just want to say that on the emergency petitions, just if you need a set of pleadings, at one time Chancellor Butler, he has an annual family law seminar. One year, Jonathan Steen and I did a thing on conservatorships, and he had done an emergency one that started and was converted to regular. So those pleadings are still available from that CLE, and that can, I'd be happy to share that or share it with Andy for y'all if you need that. I just thought that was important to add.
All right. Pam, we do have one question really quickly. I know we're at 2:01. Laura wants to know if your client will always be the petitioner. So I'll let you answer that one.
Your client might be the respondent, and there are materials to help with that too. And I think some of those resources have those things that are useful. If you're signing the petition with an individual, that individual, the petitioner, is your client. But you might be representing the respondent, you might be the guardian ad litem, or you might be appointed to represent the respondent as attorney ad litem.
Great. Well, those are all the questions that we have. Pam, thank you so much for taking your time to do this. If anybody has any more questions, let me know. It is after 2, so you all are free to go. Just please be sure to fill out that CLE form so I can submit your CLE credits and make sure that you get those. I will be sending out a recording of this as soon as I can, hopefully tomorrow, and that way it's available to watch whenever you need it. So thank you all so much. And if there's no more questions, then we'll go ahead and conclude this for the day.